And joining us this morning on this show for the first time, one of her attorneys, Alan Jackson. Alan, good morning.
Hey, Greg, how are you this morning?
Great to have you on. I know it's early out there in California. Appreciate you
Ben.
taking the time.
Pleasure.
I mean, I've been trying to get you on since the trial, but I mean, I know you had other things you had to do.
Well, you know, I need a little courting. You didn't court me, Greg. Come on.
Well, I tried.
I just love Alan Jackson.
You took to Instagram
I am a
over the
fanboy for
weekend
sure.
to say that you're not done yet, and the next chapter is coming. I know there are a lot of us who want to know what that means, Alan.
Well, I was just sort of generally referring to something I'm very excited about, which is I've agreed to join Karen and her very capable defense team in the civil action. So I'll be coming back to Boston. You haven't seen the last of me yet.
So that's pretty big news just in itself. So he's going to join the civil team in the civil case. And I guarantee you, I mean, they have a, like, look, the rules are a lot different in this civil case. We all know that. It would be pretty easy if she didn't have an above average lawyer to lose that case, because the burden of proof is way less. It's way less. And, you know, without ARCA period, or on by itself, the civil case would be a loss. She was drunk. He got out of the car. Nothing. There's no other explanation for it if you don't consider a fight and him getting jumped and unalived by Higgy Bear. If you can't consider any of that, then she's liable civilly. I think just by letting him get out of the car drunk and by her drinking and driving, she can be held responsible without a good lawyer. So praise God. And I don't say that flippantly. Praise God that Alan Jackson is going to be her lawyer, because it's the right her to win that case, and for the O'Keefes to lose that case because of their ego is the right thing to happen. It just absolutely is. So I'm so glad he's joined that team, and he's doing it just to make sure that they're doing everything possible to make sure she doesn't get found liable civilly.
And the really good news is I'm going to be bringing Elizabeth Little with me as well. So
badass!
The band is
we all love Elizabeth Little.
Staying together, getting back together, but we're intending on writing a few new chapters.
That legal team, you're the legal team that you have joined, has sent subpoenas to the Mass State Police and the Norfolk DA's office, seeking information on witnesses who testified at the trial, on Michael Proctor, and on evidence from the federal investigation. We discussed the federal investigation a lot on this show. From your perspective, in your opinion, did that federal investigation end?
Absolutely not.
No, I've never heard of such a thing. I know what Mr. Brennan said. I know what the hired gun said in court about being contacted. And there being a closure to the case. We weren't contacted. I was never contacted. I've never heard a word of that directly from the horse's mouth. And I've been doing this for a long time. And I can tell you it's not a thing. It's just not a.
And some would say, well, they don't need to contact Alan Jackson. You're right. They don't need to contact Alan Jackson, but they like Alan Jackson. They gave Alan Jackson ARCA to win that case. They would say, hey, man, we didn't find nothing. You know, just as a courtesy, they would tell Alan Jackson that, hey, man, we're closing the case, which they don't do. Federal prosecutors don't do that. They don't. I've been prosecuted federally a few times. They just don't do it. And they can wait and wait and wait until the very last minute. If there's a statute of limitation, which there isn't here because it's the big M, right? They don't have to. They can wait 10 years if they want to prosecute someone, and they're just going to let everyone feel safe and like they got away with something, and then you're going to see it, bam, 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 indictment, 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 and I just pray that Judge Beverly Canoni gets indicted in some way, shape, or form. At the very least, I hope she loses her law license. She's crooked. She's crooked. Crooked Bev. Crooked Annie Bev.
Greg, you just don't do that. As a prosecutor, especially a federal prosecutor, you don't look at the target, call the target, and say, "Oh yeah, we're done. We're done here." What if something new comes up tomorrow, or next week, or next month, and you're within the statute? You don't, quote unquote, close investigations. So that's something that I'd never heard of, and I no, in my opinion, there's no such thing as a quote unquote closed investigation. They can say whatever they want over at the Norfolk DA's office. I'm sure that was a curated comment or a series of comments, but
to the jury.
I'll leave it to the feds to do what the feds do best, and that is to investigate. And that's exactly what I think is continuing to happen. But that's just my opinion.
Speaking of that, of the DA's office, should the taxpayers in this state be concerned with how much was spent on both of these trials?
Oh God, yes. Yeah. This is the DA's office serves at the pleasure of the public. He's an elected official, and he's got responsibility to the public for their confidence and to their pocketbooks. I have no idea how much they spent. I know how much we spent, and I can imagine they spent as much or more. I mean, there were millions and millions and millions of dollars
and they justified spending that money. They justified spending that money because a police officer was killed, but it was all for their ego also to be right. And they thought they could railroad Karen Reed. They just thought they could, and they cost the taxpayers. That's why you see so many free Karen Readers, because they know she's getting railroaded, and it's their money. The people that live in Massachusetts, it's their money. And Masshole Mafia or Troll Mafia or whatever the hell she used to be called, Katie, whatever the F her name is, she's a dumb bee. I used to be in a community with her, and she's a troll. She's a self-admitted professional troll. And so everything she's doing against Turtle Boy and Karen Reed did it, and we're all delusional. She's just a professional troll. She used to admit that she was, and now she doesn't. But she does it just for clicks and views and to be oppositional. That's all she does. I'm sorry I got on a rant about her, and not all of you know who she is. She's more on X, and has some YouTube stuff. Masshole Mafia or whatever the hell she used to call herself, or calls herself now still. And I totally digressed by even getting into that. Well, all I'm saying is that's why people are so wanting to protest, and it's because of all the tax dollars that got spent on a bogus case. They didn't need to get spent. The district attorney in Canton couldn't pay one of his own to try the case, or didn't have confidence in them to try the losing case, which it's probably both can be true. So he had to pay a crooked mafia lawyer to prosecute Karen Reed, a crooked mafia lawyer. I did a whole show on it, and I'm going to leave a link in the description over there in the corner to go to that video on the replay. I did just a quick 10-minute video on how crooked Hank Brennan was in his past, and what he truly is a crooked mafia lawyer. Of course he's going to do it. It's almost $1 million, or just over $500,000. I'll say that. I don't want to be to say things that aren't true, to make my point.
Taxpayer money spent that was completely unnecessary, because of a persecution, not a prosecution, because of some sort of a personal vendetta. After the first trial, everybody knew what had happened inside that jury room, inside that deliberation room. She was acquitted. I've talked about this, the fact that Karen and I and our team may be the only attorney-client relationship where we've actually acquitted someone of murder twice in the same case with the same charges. They knew that they couldn't prove this case coming out of the first trial. They knew they couldn't prove the case going into the first trial, and that they pressed forward. And then, of course, following the debacle of the first trial and the joke that was the unrecorded verdict, they forged ahead again. And it was, it turned from a professional, objective prosecution of a case to a personal vendetta, and it cost the taxpayers millions and millions and millions of dollars. I mean, just their special prosecutor alone, his bill was north of $500,000, closing in on $600,000, just him, for a completely failed prosecution.
What I thought.
Which is odd. You worked in the DA's office in Los Angeles as an ADA.
Yeah.
You have perfectly capable ADAs who could have tried this case, and it wouldn't cost you $600,000. Correct? That's normally the way it goes. Of course.
Right? Yeah, that's normally the way it goes. And if Michael Morrissey didn't have those kinds of prosecutors who could try the case capably, then maybe he needs to find another job. That's his only job, is to populate the courtrooms with people who are competent, not just competent, but ethical. I don't know, maybe there were some ethical prosecutors inside that office who said, not just, I can't. They probably could have prosecuted the case.
No,
it's
that's
a matter of calling witnesses and doing an opening and closing statement, putting on some evidence. I think he had prosecutors who said they wouldn't, because it's unethical. They didn't believe in it. So what does he do? He goes outside the parameters of the contours of his office and finds some defense attorney to come on board and switch hats midstream and become a prosecutor. It's outrageous. You just don't see this kind of thing.
Alan, I was so impressed with how you and your team were able to handle the first trial and the second trial, but it did feel so drastically different, the way in which you decided to handle witnesses. And the first trial seemed like there was just bombshell after bombshell. It was much more McAlbert's heavy, while the second trial was much more database. What went into the decision to kind of switch things up and choose to go down that road at the second time around?
There wasn't a...
I'll tell you exactly what it is. They focused on the second trial. They focused more on creating reasonable doubt, and you could tell from the after the second witness, they're like, oh, they're gonna make sure that they create enough reasonable doubt with each witness, because really, with just one, if you can create a reasonable doubt with just one witness, that's the whole trial. It's done. It's done. They're like. That's reasonable doubt. You know, the proof that they're trying to testify to as a witness, if there's just a little bit of reasonable doubt, that's reasonable doubt in itself. You don't even need to do the rest. But they did it with every single witness. Not one witness for the prosecution had any kind of factual basis proof that John O'Keefe was struck by her SUV, or that there was that they were in a fight, or that she had ill intent to hurt John O'Keefe, and the damage, the planning of all of it, man. It's just crazy, man. It's just crazy. But yeah, that was the new strategy. But I'm sure he's going to say that.
In what our theme and theory of the case was. As a matter of fact, there was no difference in what our theme and theory of the case was, which is the SUV never hit John. He wasn't killed by being hit by a car. That's the basic postulate. In the second trial, it was very clear that the prosecution was going to do something different. They were going to try to style themselves as a data-driven prosecution. We knew that the data helped us. So any trial lawyer has to do this. You have to be committed to your cause, but you also have to be able to be up on the balls of your feet. You have to be able to be nimble and pivot with the prosecution, because you're not just parrying, you're defending,
Nimble.
but you're also, to a certain degree, you're on the offense as well. So what we decided to do was shift and learn from the first trial that I wanted to press much harder on reasonable doubt and undermining everything they say about the data, because the data actually served our purposes. The data proved the car did not hit,
it was crazy.
did not collide.
It was
with John
almost
O'Keefe.
it was
So that's
almost like every single witness was a defense witness. Like truly, they didn't even have to put on their case, but they had such good witnesses